Good morning. Happy Wednesday. Welcome to the Courtroom Files Live. We will start our day, not our week, our day. It's Wednesday already. We'll start our day with Judge Simpson.
Truce, what you got?
Yes.
Okay, go ahead and lower your hand. Say and spell your name out.
My name is Aaron Salazar.
Can you spell it?
Aaron Salazar.
All right. Let me just do this because my file here is a mess. And he's going to plead to the charge of operating while intoxicated.
Correct.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
I guess we'll wait. Yes, sir. Okay. You understand all of those maximum penalties, sir?
Yes, I am.
All right. Understanding that, how do you wish to plead?
Plead guilty.
You want to plead guilty or not guilty to?
I am guilty.
Pardon?
I am guilty.
Guilty?
Yeah.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
No trial.
Not right.
All right. You signed an advice of rights form. Is that correct?
Yes.
Correct. Yes.
All right. Do you have any questions regarding any of those rights?
No, I don't have question.
All right. On the podium, I need you to look at paragraph 5. Now, those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Understand all that. We went through this.
Yes, I understand.
All right. You understand you're giving up those rights.
Yes.
All right. You understand that you're giving up your right to appeal of right. What that means is that if you don't like the fact that you have a conviction or your sentence, you have to ask permission of the higher court to hear your appeal or your complaint.
You're giving that up. Yes, we want to do that.
Yes.
All right. Are you on probation or parole? Let me ask it this way. Are you under the jurisdiction of any other court?
No.
This is his first interaction ever.
Ever? Okay. And so you're not on parole. You've never been to prison for longer than a year.
No, never.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
Nobody's promised you anything except the plea deal.
Yeah, yeah.
So
Okay.
nobody's promised you anything except this plea deal.
Oh, yeah. Yes.
Is that correct? Has anybody threatened you or coerced you or forced you in any way to enter this plea?
But he threatened you to get you to enter this plea, to threaten to harm you. Nobody's threatening you to get
No,
you.
no, but
Okay. You're doing this voluntarily and of your own free will?
yes, I did.
Okay. And you're also doing it because you believe that you're guilty of this offense?
Yeah.
Okay. October 21st, 2024, at Oak Valley Drive near Target in Pittsfield Township, Washtenaw County, state of Michigan. Were you driving a car?
Yes, I will.
Okay. Before you drove the car, had you drank alcohol?
Before?
Yeah. Were you drinking prior to driving?
Why?
Were you drinking prior to driving? Drinking alcohol prior to driving?
Yes, I was.
Okay. Were you stopped by the police or was there an accident?
There was an
That
accident.
was an accident.
Okay, what happened?
I was having problems with my wife, so I made a wrong decision. I was drinking and I was go home, and what happened? The accident.
What did you hit?
A signal for the pedestrian.
Got it. All right.
It's a crosswalk sign on Oak Valley Drive there.
Did the police arrive?
Did the police come?
Yeah,
Okay. Were you arrested?
yes, I was.
Okay. Were you taken to the hospital for a blood draw?
Yeah,
Okay. Do you know the results of that blood draw?
It's 0.176, Your Honor.
Okay. Do you have any reason to think those blood test results are wrong?
Did you think they were wrong that you?
no, I don't think so.
All right. All right. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor, the people are satisfied.
And defense is satisfied, Your Honor.
All right. Court will accept the defendant's plea of guilty to count 2 DOWI. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
June 25th, that's Friday.
June 25th, 2025, 9. Bond with its conditions will continue.
I think that also may be a vacation. Your Honor, can I get the next date after June 25th?
What day?
July 9th.
I would really like to stay married.
You know, July,
I outkicked my coverage, so I don't want to lose it.
July 9th, 2025, 9 a.m.
Thank you, Your Honor.
All right, thank you. Bond continue. Court calls the case, People versus Mohammed Aldel Haber.
Christina, people.
Your Honor, good morning. I'm Mohammed Abdul Jabbar.
Okay, you don't have an attorney on this case?
Negative, sir.
All right. Where are the rest of your pants?
Oh, sorry, I'm going to work right
Next time
after
you
this.
show up, we'll
Yes, sir.
make sure you have all of the pants.
Absolutely.
All right. Okay. Why is this on my docket? The last thing I have on here is he warranted. Did you turn yourself in, sir?
Yes, sir.
All right. And then you went before the magistrate.
No, I came to the court and I got a letter in the mail saying to appear today. I got pulled over. The cop told me I had a warrant, so I came the next day to address it.
He filed a warrant. Okay, got it. Okay, so you're here on a pretrial.
Yes, sir.
All right, and it's a driving while license suspended.
Yes, sir. And I did have a brief monologue with Miss Landy, and I think we came to terms about the prosecutor.
Yes, Your Honor, we had a conversation with him before.
Okay.
And we'd just like to ask if he has a valid license. License is valid.
It's currently valid but restricted,
It's
Your Honor.
restricted, yeah.
Yes, sir.
Yeah, he does have a valid license, but it is restricted.
Up until August of this year, Your Honor. August 27th.
Hang on a second. Let me just check it. Make sure. What's the restriction for?
Just no moving violations. That's the only restriction. And I currently don't have any. So.
Hold on a second. Oh, I see. Yeah. When I'm looking Oops. Yeah, okay. His only restrictions, if you don't see it, are that he can't drive a vehicle requiring a commercial driver's license and no moving violations. But that's the only restriction.
Okay, okay. Your Honor, given that his license is valid, the people move to dismiss.
Right, he did that all by himself?
Sorry?
He did that all by himself?
Yes, sir, I do.
After County, he did that all by himself and only had half his pants. All right.
I'll tell you what, like I do watch a lot of your videos, so I was educated before I came in here, definitely.
All right. This case is dismissed. You have a great day.
I appreciate it, Your Honor. Thank you.
Take
Your
care.
Honor.
Court calls the case People versus Abdallah Bader.
Good morning once again. Welcome to the Courtroom Files Live. I will argue that if he watches enough of Judge Simpson's videos, he should have known enough to show up with all of his pants. Just saying. Let's get back to Judge.
Order to show cause, Your Honor?
Yes.
Thank you.
Court calls case People versus Candace Brooks.
Good morning, this is Civil Defender Lauren Kearney on behalf of Ms. Brooks, who should be on Zoom. Oh, no.
Candace Brooks. Well, Miss Perrony.
Well, Your Honor, we had a resolution today. I was speaking with her and yesterday, and she was intending on being here. I don't have an explanation for the failure to appear, unfortunately.
The individual whose phone number ends in 999, could you identify yourself, please?
Guard Robertson.
Not her.
For the record, I don't have.
Bench warrant will issue for defendant's failure to appear. Bond is set in amount of 5,000. Give it 10% per.
Guard Robertson.
I got you. We don't have your case yet. That warrant on this case will issue immediately. Court does call the case People versus Ashton Ebler.
Ashton Neebler.
Thank you.
Sorry, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Ebler, who is present via Zoom and has already stated his name. Your Honor, I'm respectfully requesting one last adjournment. The people did provide me with an offer yesterday afternoon that I do need to discuss with the client. There is an also other potential resolution that I still need to discuss with the people as well.
That's correct, Your Honor. There's a few moving parts here. We're looking for a little bit more time, please.
June 18th, 2025, 9 a.m.
Thank you, Your Honor.
On continued. Thank you, sir.
Thank you.
Court calls case People versus Ashley Garcia.
Ashley Lonnie for the people.
Agreement for each other.
Ashley Garcia. No response. I'll issue an order to show cause. Court calls the cases of the People versus Larry. Is it Geekman?
Ashley Lonnie for the people.
Good morning, this is Civil Defender Lauren Kearney on behalf of Mr. Aikema.
All three cases.
Good morning, Your Honor. Larry Geikema.
There he is. Okay, thank you. All right, what are we doing?
Your Honor, we have come to a resolution. Mr. Aikema is going to plead to no operator's license on this person as an added count 2 on the case ending in 1747.
No ops.
Yes, Your Honor.
And in exchange, count 1 on that case will be dismissed, as well as the cases ending in 1748 and 146.
That is correct. The no ops being a $100 fine, contrary to 57311. That's a complete recitation of the plea agreement, Your Honor.
All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again for the record, please.
Larry Geikema.
All right. You can put your hand down. I think that was your left hand, but that's okay.
Oh,
All
you're
right.
right.
What'd you say?
I said you are correct.
Yeah, thanks. I just gotta let it go, but all right. Sir, it is this court's understanding that you're gonna plead guilty to the charge of no valid operator's license on person. That is a misdemeanor, punishable by up to 90 days in jail and a $100 fine plus court costs. You understand that?
Yes, Your Honor.
And understanding that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you.
Sorry, Your Honor, he did sign an advice of rights form.
Is that correct, sir?
Yes, Your Honor.
All right. Left hand and you're late on getting the information.
Well, I had it.
Oh, it's okay.
It's
Okay.
just, I didn't want to interrupt you because you were so eloquently explaining his rights, so.
Wow. Okay, sir, you signed an advice of rights form.
I did, Your Honor.
All right. You have any questions regarding any of those rights?
No questions.
All right. You understand that you're giving up all the rights contained on that form, including the rights contained in paragraph 5, your trial rights.
I understand.
You also understand you're giving up your right to appeal of right?
I understand.
All right. Are you on probation or parole?
No probation or parole.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Absolutely.
And because you believe that you're guilty of this offense?
Yes, sir.
August 13, 2018. Location of westbound I-94 in Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
I was.
Were you stopped by the police?
Yes, sir.
Did they ask you for a driver's license?
Yes, sir.
Were you unable to give them a valid license?
That is correct, Your Honor.
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied. Satisfied, Your Honor.
All right, court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I impose sentence?
Nothing. I just have one question about fines and costs. Before this court date, I had paid 2 of those tickets, $100 each in full, and put $80 towards another ticket. Will this money go towards my costs and fines now?
You paid.
So I looked up the cases in JAS, and that does reflect that he's paid about $280. On May 21st, he didn't appear before Your Honor, and the court adjourned it to today. He paid some money, I think A, to display to the court that he was serious about resolving the cases, and B, to get ahead on some fines and costs.
Hold on a second. He.
I do show that back in 2021, but I did see a payment of $100 on 5/21 as well, unless I might be mistaken, and maybe that
521 of.
this year.
You see a.
So I see an $80 payment in the case of 1748.
That was on a different. I see what I think what he might be asking is he paid money on the cases that have been dismissed as part of this.
Correct.
That's what he's asking, but he hasn't paid on this case. And I don't.
There's also a couple civil infractions that are floating around in JIS, so I'm not sure if
This is 1748 that he paid on. I don't.
Yeah, he paid $80 here and $100 on the 1464 one. He should not have been able to receive those payments because they are pending cases.
Okay.
So he,
Okay, I got it.
Yeah.
So he's paid a total of $180.
that's what I see.
I do.
180.
Pardon?
It should be 280. I paid two separate $100 payments and one $80 payment.
On 1747 on the financial screen, that's $100 paid on 521 using the credit card. It says warrant.
Okay. Right, because he had to clear his 2 warrants. So that one's out. On the other cases, he's paid it. On the other files, he's paid what? You said 180.
I see $80 on case ending 1748. That was on 521.
And what was,
That went towards state things.
really?
Yeah,
$80? Okay.
$80.
All right.
And then in the 2019 case, he paid $100, but again, that went towards warrant fees.
So the 100 on the one went to warrant fees to clear the warrants.
So $80 is what I see.
But they weren't in.
They were in, I know the 1747 was in warrant status.
But they weren't in warrant status at his last court date
Right.
because he was set before for a pretrial before Your Honor.
His last court date was, well, I have May 12th, but it may have been the 21st. Alan was having it this year.
Yeah, May 21st, and he did not appear, but because he had a valid license, Your Honor adjourned it to this day.
And continued his bond. But when did he pay?
It's, sorry if I don't interrupt you.
No, go ahead.
It says the warrant was canceled on 4/11, bench warrant requested granted by the judge, warrant canceled, previous bond reinstated. So I don't know if, because those warrants existed,
So here's the thing. He gets, it's going to be a $50 charge when the warrant is issued.
Right.
So I'm looking at the card stock, and I issued, or the court issued 2 warrants against him.
Yeah.
One on October 31st of 2018, and then another warrant on June 16th, 2021.
yes.
And so those fees were there, and even though he might have cleared it, he would still owe the warrant fee.
And now that they're dismissed,
Well, I'm talking on the case that,
the one that he pled on.
the one that he pled on, I'm saying. He would still theoretically, even though those cases were dismissed, still owe the warrant fees.
Okay.
All right, so on the $200 payments that he made, right? And normally we would waive those. So I hear what, I think, right, once, right, that's what I would have done. But they were paid as warrant fees, not payments. Okay, that's on that case. On the 1748, which I still don't understand how this happened.
I think it was a clear error when they received it because.
You think?
There are, on that case as well, $100 in warrant fees assessed that are not paid.
Okay.
We don't usually have people paying their fees in advance, so this is kind of throwing us for a loop.
Yeah, I'm shocked. Other than the left hand, I kind of like him. He paid everything.
To be frank, Your Honor, he felt really bad that we missed the 21st, so he wanted to.
I know. I get it. He Yeah, and I'm just trying to figure out a way to. Can I take, here's what I want to do, and I don't know if I can. I want to take the 2 warrant fees. I don't know what to do with the $80 because that's weird, and I don't want to mess with it. I want to take the warrant fees on this case and the warrant fees on the other case, apply it to his fines and costs, and close this case out.
The $200, close it out and waive any balance over the 200.
He's not gonna have a balance over to it, because I'm gonna assess fines and costs of 200, but I need that money to go toward these fines and costs.
That's fine. Give me I'll take the files when you're done.
Well, okay. All right. Now that we've gone through that. Sir, anything else you want to say before I impose sentence? Now that you caused all this problem?
No, no, Your Honor. Thank you. I'm sorry about
All right. No, it's fine. It's the sentence of the court. I'll suspend 90 days in jail. I'll order fines and costs of $200. The warrant fees, which were paid on 1747. What's the other case number? I gave it up already.
1464.
And on case 1464, those warrant fees will be applied to the $200 because he's paid 200 there, and then we're good. Okay?
Okay.
You're all set,
Thank
sir.
you.
Thank you. Take care of
Thank you.
yourself.
You as well.
All right.
Bye.
Let's change it up a little bit. We'll head across Lake Michigan, and we will go say good morning to Judge Mogan in Wisconsin.
I am, Your Honor, yes.
Excellent, thank you. I know that she was not quite sure if her jury trial would be done. Okay, and I have Aaron Marco, Miss Achterling. We will go on the record in the matter 25 CF42, State of Wisconsin versus Stephanie Achterling. The state appears through District Attorney Kevin Schmidt in person. We have Joel Larimore, who is appearing by video conferencing, making a special appearance on Ms. Achterling's behalf, as Ms. Perrin is currently in a jury trial. We have Ms. Achterling appearing by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. Mr. Larimore, can you please give me an update on this matter?
Your Honor, it's my understanding that they are waiting for a bed verification at treatment, and so they can request a bond modification. That's about the information that I have, Your Honor.
Okay. Okay, all right. Well, did Ms. Perrin give you any other dates that she may be available? You're muted.
June 27th in the morning, June 24th in the afternoon, July 17th by Zoom.
Just wait 1 second. June 24th, June 27th. So far, those aren't good. What's the next?
July 17th by Zoom.
I have 2 jury trials. That doesn't work.
Those are the only dates that she gave me, Judge. I'm sorry. She said otherwise Cass would have to help with dates, and that I think Cass might be.
What that could be this telephone number that's trying to come in. What did she say available for the 27th, you said, perhaps?
June 27th in the morning, Your Honor.
In the morning? Could she do perhaps 11:30?
I'm going to say yes, Your Honor, because she said in the morning, so I'm just going to, I think that's
all right.
Fine.
So we'll just schedule her for June 27th at 11:30. That should work. Okay, all right. Anything further?
No, Your Honor, not from us.
All right, thank you. Who is the 715-833-2336
Hi, good morning, Your Honor. This is interpreter Darius Torres.
Oh, for Miguel? Oh, right. Okay, for Miguel at 9:15. All right, we'll be there very shortly. Okay, Mr. Furcus. Well, first I'm going to go to Mr. Marco and Ms. Chapman for Ms. Perrin. We will go on the record in the matter 24 CM 230, State of Wisconsin versus Deborah Chapman. Ms. Chapman. We have appearing by video conferencing Special Prosecutor Aaron Marco. We also have Ms. Chapman appearing in person with Counsel Joel Larimore appearing by video, making a special appearance on her behalf here today, filling in for Shirley Perrin, who is currently in a jury trial. We're scheduled for a status conference. Mr. Larimore, can you please update the court?
Your Honor, Ms. Perrin, I believe, is waiting for a video to review. She's received an offer, but wants to talk to Mr. Marco a little bit more, I believe.
All right. So let's just schedule her for that June 27th at 11:30 for a return status, June 27th at 11:30.
If I could just check my calendar, maybe I already have stuff.
Sorry, Mr. Marco, I completely forgot that we have to make sure that it works for your calendar as well.
I'm
I do
sorry.
have your other dates. What, Mr. Marco?
The 27th won't work. I'm sorry. You said June 27th, right?
Yeah, June 27th.
Yeah, I'm sorry. That date won't for me. I do know we were kind of blocking out times, but I don't remember what days.
Well, let me just schedule it and see what we can do, but I'm going out to August 11th. So it is August 11th. I know Mondays are kind of iffy with you, Mr. Marco, but I'm not even sure if this is going to work for Ms. Perrin, but August 11th at 10:30.
That's in the middle of our intake. I would need something during my ADA's time slot so that I could, which is 3 p.m.
What about August 12th at 2:15?
That is wide open at the moment.
All right, August 12th at 2:15. We'll schedule it for return status, August 12th at 2:15. If it doesn't work, Ms. Chapman, for Ms. Perrin, she'll contact my assistant and we'll just make sure that we get something that works for everybody, okay? You can come get your notice. Mr. Anthony Chapman and Mr. Furcus. We will go on the record in the matter 24 CM 229, State of Wisconsin versus Anthony Chapman. The state appears through Special Prosecutor Aaron Marco by video conferencing. We have Daniel Furcus, Defense Counsel, in person with Mr. Chapman. We're set today in this matter for a status conference. Mr. Furcus, can you please update the court?
We're not resolved at this time, Your Honor, but I think it's likely to resolve.
Mr. Furcus, can you make that August 12th at 2:15 date and time work? Zoom is fine.
I have 2 trials set for that day.
All right. I believe you are going to be with me July 31st at 11. Is that correct, Mr. Marco?
That is correct.
Does July 31st at 11 work?
Yes, Your Honor.
All right, July 31st at 11.
That is all I have. Thank you.
All right, thank you, Mr. Marco. Mr. Marco, I will, my assistant's out for the next couple days, but on Monday when she returns, I will ask her about that July 31st at 11 date. Just to see if we can have both of the Chapmans together, but as long, I do have another date for you, so I'll just use that August 12th date. So that's going to be kept open anyway.
Okay, but if Miss Perrin does need to change it to that date, I can tell you now that that's fine with me.
All right, thank you, Mr. Marco.
Thank you. Have a great day.
We are adjourned.
Grab that notice and I'll meet you out in the hall, okay?
We will go on the record in the matter 24 CF 162, State of Wisconsin versus Jack Fenton. This date appears through District Attorney Kevin Schmidt in person. Mr. Fenton appears by video conferencing in custody in Burnett County Jail. We have Joel Larimore making a special appearance on his behalf here today, filling in for Attorney Charlene Perrin, who is in a jury trial. We're set for a status. We have a final pretrial on August 28th and a 3-day jury trial in September. Mr. Larimore, is there anything that you can update the court with?
Just that there's no resolution, Your Honor.
No resolution. All right, so there's no resolution. What I'm going to do, I know we have a final pretrial, but I am going to schedule him for a status on August 12th at 2:15. Hopefully that date and time does work for Ms. Perrin. Then we can have a status and see if we can have the parties work a little bit harder prior to the final pretrial to see if the matter can resolve. So I'll schedule her for that August 12th at 2:15 date, okay?
Thank you, Your Honor.
All right, thank you. We are adjourned. We will go on the record in the matter 24 CF 59, 24 TR 265, State of Wisconsin versus Avery Weaver. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Weaver appearing by video conferencing in custody in Burnett County Jail. We have Joel Larimore making a special appearance on his behalf here today. He is filling in for Charlene Perrin, who is in a jury trial. We're scheduled for a status conference. Mr. Larimore, can you please update the court?
On this one, I have notes that Ms. Perrin needs to talk to the client about the offer.
All right. Mr. Schmidt, can you please update the court as to what the offer is? Would it be similar to co-defendants?
No. Via plea to counts 1, 3, 5, 9, and 13, we'd get a PSI. State would be capped at PSI recommendation, cost restitution, joint several with Katie Mortensen. Defendant would be free to argue.
All right, okay. What I'm going to do, Mr. Larimore, is schedule it for that August 12th at 2:15 date, August 12th at 2:15. Hopefully that date works for Ms. Perrin. Otherwise, we will be scheduling it for one that works with everybody. All right, then we are adjourned. Thank you.
Thank you, Your Honor. I think that's all for me.
Let's head back to Michigan and Judge Simpson now.
I have no probation intake.
You do not have it today.
Okay.
His paper is here. Oh, he's.
Oh, here it is.
Ashley, for the people in the Artuso matter.
Court does call the case People versus Artuso. All three cases.
Assistant Public Defender Natalie Pate with on behalf of Mr. Artuso in the cases ending in 1656 and 1657.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso. It's the remaining matter set for pretrial, Judge.
Okay. Your name, sir?
Rick Artuso.
Thank you. All right, what are we doing?
Your defendant is set on Tuesday for a preliminary exam in a different case that involves the same victim as the larceny case in this case. So the people and defense are requesting to adjourn this matter to allow the preliminary examination to go first.
All right, and that's on your case.
That's correct, Your Honor. I represent him on both on the other matters as well, but that's correct, Judge.
Got it. So that one I will adjourn to June 18th,
Yes.
2025, 9 a.m. Bond will continue in that matter.
Thank you.
All right.
And I would also request an adjournment as to these two matters, Your Honor. This is a ticket case that I've been in discussions with the people about, as well as my client. I don't know if we'd be able to resolve it by the 18th. There's a world in which we could, but I would not be opposed to a later date.
Okay, I'll see.
That's correct, Your Honor, and Ms. Payton and I have been trying to work onto it. This may be one case that ended up in, just maybe one ticket that ended up in two cases, and maybe the same ticket just got duplicated somehow. So we're working on that as well.
Oh, where he was written for two things on the same ticket.
Where he was written one ticket, or it was entered twice, or two things on the same ticket. I can't recall off the top of my head right now, but I do believe it may be one of those.
I believe that it was a duplicate case. I think it was just entered twice. But
no, you mean 1657 and 1656?
Yes.
No, there's so you don't have a copy of the ticket.
We do, and we have the same discovery that we've been provided by.
So the ticket was written for two charges.
Correct.
And they're just in two cases. So
they're both, well, the discovery I have is they're both charged twice on each case. But regardless, I have been discussing.
So you have it, so I don't, what do you have? Hold on.
I have that both cases are charged for DWLS and operating unregistered vehicle.
I don't know where you're picking that up from. When I'm looking at the JAS printout, the card stock in the case and everything else, I have 1656 as a DWLS, which is the first charge on that ticket. Mm-hmm. And then 1657 is the no insurance.
Oh, I see. Thank you.
Okay, thank you. That's probably correct.
So
yeah.
they're not duplicated. They just come out of the same ticket.
Thank you, Your Honor. Very helpful.
So are you looking to try to have him potentially in a position of clearing his, I mean, how much time?
Potentially, my client thought he did have a valid license. I was able to run his driving record on my end. I show that it's currently suspended.
He's right.
Oh.
Yeah, he has a valid license.
That's great.
Yeah. So let me just make sure when that was run. As we received our response, SOS response on May 28th, just a few days ago.
Okay.
And his NCL he's valid.
Perfect.
He's got a valid.
He was right. I believed him. I must have run it incorrectly or entered the wrong date of birth from Mr.
So he's got a valid license. I don't know if that helps.
Your Honor, the people would offer if there is a plea to the unregistered vehicle, you would just
the other ticket. So if he pleads to 1657.
Yes.
Thank you, Your Honor, and thank you, Ms. Londy.
All right. So what does he want to do? Do you want me to adjourn it?
I would ask for a brief adjournment to discuss this with him again.
So I'll adjourn both cases out then to the 18th, 9 a.m. and hopefully we'll be able to get it resolved then.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Continue. Let's call the case of the people versus Justin Goltowski.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Goltowski, who should be present via Zoom. Sir, can you please unmute and state your name for the record?
Justin Goltowski.
Thank you, Your Honor. So Mr. Goltowski has left me several emails and I've left him several voicemails. That being said, we have missed each other on all of those communications. I'd respectfully request a brief adjournment so I can discuss what he would like to do with this case and next steps.
June 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Thank you, Mr. Goltowski. You're all set for today. We'll make contact successfully before next time.
Okay, thank you.
Nice parody against the wall.
I think she just moved out of the way for the last defendant. Manners.
Because she has manners. Court calls the cases of the people versus Vincent Dunlap.
Ashley Lonnie for the people.
Conrad Solar on behalf of Pittsburgh Township.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Dunlap.
And good morning, Your Honor. If it please this honorable court, Brandon Byrd, also on behalf of Vincent Dunlap. Mr. Dunlap, can you please state your full name for the record?
Vincent Edward Dunlap.
Thank you. All right, what are we doing?
Your Honor, we did all have a conversation with all relevant parties in these matters. I believe Mr. Byrd and I are requesting adjournments on the 3 files. Mr. Dunlap has a felony that's before Your Honor tomorrow. And the resolutions on these files may follow what happens on that felony case.
Gotcha. So would the 18th be enough time, we think, or?
I'd ask for one more just in case.
What's after the 18th?
July 2nd.
All right. I'll adjourn all of these then to July 2nd, 2025, 9 a.m. He does have minimal bonds on. Yeah, he has $100 bonds on all of these, so. All right, thank you.
Thank you.
Thank you. I wasn't about to argue this time, yeah.
What?
I wasn't about to argue mine this time.
Were you? Oh, no, go ahead.
No. I was. Thank you, Your Honor, for the court.
All right, take care of yourself, sir. Let's call the case of the people versus Christopher Holt.
Ashley Lonnie for the people.
Good afternoon, Mr. Public Defender Lauren Perny on behalf of Mr. Holt. Mr. Holt, please state your name for the record.
Christopher Holt.
Thank you, sir.
Yep.
Yeah, we have come to a resolution. Mr. Holt would like to plead no contest. I will admit my fault. When they exist. I did provide the court with a police report last night, which I know is over the deadline. I did speak with Mr. Holt regarding the possibility of a adjournment. However, we are prepared to report this today, depending on.
Yes, my staff let me know that you sent it late, but I took the time, Miss Perny, last night to go over the police report.
Thank you, Your Honor. I appreciate that.
There'll be no more favors.
Fair enough.
All right. Okay. What's going to be the plea?
So he's going to plead to an added count of larceny under $200 in exchange for a dismissal of count 1.
That's correct, Your Honor.
That's a no contest plea.
Yes.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name, please.
Christopher Holt.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of larceny under $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, I do.
All right. 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court's going to treat you the same as though you had pled guilty to the charge. You understand that?
Yes, Your Honor.
All right. So understanding all of that and the basis for the no contest plea.
Such a civil liability, Your Honor.
All right. So, sir, understanding all of that to the charge of larceny under 200, how do you plead?
Plead no contest.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form. Is that correct?
Yep.
Any questions regarding any of those rights?
No, Your Honor.
Under paragraph 5, those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
Nope.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes.
All right. As indicated, the court has been provided, albeit late, Pittsfield Township Department of Public Safety report for their case number 252506. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied. Satisfied, Judge.
All right, court will accept the defendant's plea of no contest to count two. Count one is dismissed. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be June 25th, 2025, 9 a.m. Bond will continue. All right, I don't have probation intake on the screen, so you'll have to call over and make an appointment with our probation department. Okay, sir?
Yes, Your Honor.
All right, thank you.
Thank you. You have a good day.
You too.
Bye.
Court calls the case, People versus.
Alrighty, friends, I wanted to let you know that we here at the Courtroom Files, the entire team works incredibly hard to bring you these shows every single day. As an example of that, here is co-host Ellie. She has this morning made very certain that all of the cables that bring you this show are staying warm to make sure that the data flows as quickly as possible to all of you. Yeah, and you're not afraid to tell people that you're working hard either, are you? So, just thought I'd let you know we're all working real hard here for you. Let's change it up. We'll go to Judge Anslow, and we'll move just a little bit to the south. Say good morning to her.
You were working there?
Yes.
All right, and you had access to somebody's identification cards or money or checks, is that correct?
Identification, yes.
Yep. Was it a patient there or an employee there?
A patient.
Okay, and you took that item?
Yes.
Okay, and did you take some checks too?
No.
Okay. All right, Mr. Sneed?
Your Honor, we're satisfied with the fact she'll admit to taking identification.
All right, and you had no right to take that, correct, Ms. Ford?
No.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Mr. Fry?
Yes, Your Honor.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I'm going to set this for sentencing on July 18. Are you available that day, Mr. Fry?
Yes, Your Honor.
All right, July 18 of 2025 at 8:15 in the morning. I'm going to ask that be in person. That doesn't mean anything, Mr. Fry, but I am asking for it to be in person. So, Ms. Ford, I'm going to put you in a breakout room with Mr. Jones from the Michigan Department of Corrections. He's going to give you some instructions, how to meet with them, how to complete an evaluation and the paperwork they need. You're going to have to come and meet with them in person, which is fine because you live local. And then they'll prepare a pre-sentence report. When you meet with them, be truthful about your background and the events that occurred. They'll put it in a report. We'll provide a copy to Mr. Fry. Mr. Fry, make sure you call him in before sentencing and review it with them. And okay. Is there any restitution, Mr. Steen or Mr. Fry?
There is restitution. That's part of the plea agreement, that it would be paid by the defendant as ordered by the court. So
how much
I
is
presume there'll be an amount included in the PSI.
Okay, so we don't know how much. Okay. I think I have 95, 65. Is it that minimal amount?
Your Honor,
Show it.
I would have to review the police report again.
All right, so, Mr. Fry, do you wish to go in the breakout room with her?
Sure, Your Honor.
Okay, so I'm gonna open up a breakout room, Ms. Ford, and you're gonna go in there, your attorney and Mr. Jones. Mr. Jones will get your contact information and make sure you show up for those appointments. So Brian Fry, Brittany Ford, and Ms. Jones, go ahead and join that breakout room. Oh, yeah, I do. I have one. All right. Okay. Thank you. Joanne Spade. We have a new file. Okay. Okay. All right. So let's reorganize. Mr. Madison.
Yes, ma'am.
I know. Hold on one second. All right. This is in the matter of the people of the state of Michigan versus John Madison. We have two files, 23-2.
That's Brandon Madison.
Oh, wait. Well, I asked for John Madison, but do I have Brandon Madison too? No, yes, no, hold on. No, I don't. They gave me the wrong Madison. It's good to see you though, but will you tell them I need, will you tell them I need the other one?
Okay.
All right, have a good day.
Yeah.
All right, moving on. All right, so I have another gentleman in the jail. What's your name, sir?
Rodriguez.
What's your name?
Me?
Yeah.
Jacinto Rodriguez.
Okay, thank you, Mr. Rodriguez. Hold on one second. What's your name now?
Gerald Overall.
Spell your last name?
Overall.
What's your first name?
Gerald.
Gerald. Are you just here to watch?
No, I'm here. They said something about they sent a jury duty letter to a mail, some mailbox.
Oh, all right. So did you go to the clerk's office?
No.
All right. So I'm going to send you down to the clerk's office and to ask for Phyllis because she does our jury questionnaires and she'll take care of you down there. All right.
Okay, thank you.
Thank you, Mr. Overall. All right. So that's round one. This is Mr. Rodriguez. All right. So get your file, Mr. Rodriguez.
Thank you.
Okay, this is in the matter of the people of the state of Michigan versus Jacinto Rodriguez, file number 25-22282AX. So hold on a second because this is an extradition. So Mr. Rodriguez, we are here today on a proceeding to determine whether you wish to waive your right to extradition.
Yes, ma'am.
Extradition is a proceeding to return you to another state in which a warrant has been issued for your arrest for the commission of a felony. It is in effect a demand by another state for your surrender and to return to that state to face the crime with which you are charged. So you are charged by Sandusky County, Ohio, on a pending arrest warrant charging the crime of felony 5 possession of drugs, which is a felony in the state of Ohio. We cannot, in this court in the state of Michigan, determine the truth or the falsity of the charges made against you in the state of Ohio. You do not have to waive your right to extradition. You can require that the governor of the state of Ohio make demand upon the governor of Michigan for a warrant for extradition. You have the right to demand and procure legal counsel. If you cannot afford an attorney, we will appoint one for you at county expense. If you or your attorney wish to test the legality of your arrest, you may apply within a reasonable time for a writ of habeas corpus. That is a writ by which your custodian is required to bring you before the court for the purpose of having a hearing to determine the legality of your arrest. Do you understand the rights that I've just told you, sir?
Yes, ma'am.
Would you like a court-appointed attorney at this time?
No.
Okay. Do you want to waive your right to extradition to a writ of habeas corpus and to an attorney and go voluntarily to the state of Ohio to face the charges made against you in that state?
Yes, ma'am.
All right. Did they give you the forms to sign?
I have nothing.
Okay, will you tell them you need the extradition forms to sign? I know we already sent them over there. So I
Okay.
gotta have you sign them and swear you in. So I don't, hold on, we're there.
Good morning, Your Honor.
Hey, so this is Judge Anslone. Mr. Rodriguez needs his extradition forms.
Yes, ma'am, we'll get them to him.
Awesome, thank you.
No, first.
So they're gonna bring the forms to you and I'm gonna have you sign them and then I'll swear you in and make sure you sign them of your own free will, all right?
Okay. So what exactly happens at this point?
Okay, so if they have not. They put me on hold at the jail, that's fun. So if they don't pick you up within 14 days, I'll bring you back into court, okay?
Okay.
Isn't Ohio pretty good about? Yes. Ohio's pretty good because they're kind of close, so they pick
Yeah.
up pretty fast.
Okay.
Okay,
Then, so I get there, they arraign me and then give me a bond or something?
I don't know what Ohio does.
Okay. Okay.
No, so I'm assuming you'll just go through your court process and depending on your past history and the charges you're facing, they'll either give you a PR bond or a whatever they do.
Okay.
All right, so give us a minute while we're waiting for those. Mr. Noe, I know you're here, but I have a couple other people that were here in front of you, so I'm sorry.
No, I understand. Thank you. You can't get rid of me, Judge.
You're here all day long. Mr.
Yeah.
Dagger Margosian, did we finish Mr. Party?
No, Your Honor.
Is he there? Where'd he go? There he is. Okay. I lost him. I couldn't see him. All right. Grab his file. So, in the matter of the people of the state of Michigan versus Daniel Benjamin Party, file number 25-22258FH. I have Michael Dagger Margosian appearing on behalf of Mr. Party, and I have Isaac Sneed appearing on behalf of the people. This is a date and time set for a pretrial conference in this matter. Mr. Dagger Margosian, how would you like to proceed?
Your Honor, Mr. Party is going to be pleading guilty as charged, no subs, no objection to no upfront jail. And at sentencing, I'll be asking for a probation transfer. He lives in Mecosta.
All right, slow down, Mr. Dagger Margosian. So he's pleading guilty as charged with no subs. There's an agreement between the prosecutor's office and your office that there'll be no upfront jail.
Correct.
And I don't have control over the transfer, that's MDOC, but if he lives out of county, we'll automatically do that anyway. So he will have to report to the probation department here a couple times before that, all right?
Yep.
Okay, Mr. Sneed, is that a correct recitation of the plea?
Yes, it is, Your Honor.
All right, Mr. Rodriguez, did you get your forms yet?
No, ma'am.
All right, no, they're on their way. All right,
Okay.
Mr. Party, do you pronounce it Pardee or Party?
Party.
Just like, all right, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, so, Mr. Party, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty? Hold on, let me get to the felony information as charged, and there's no subs, Mr. Dagger Margosian? Right?
There are, but those are being dismissed.
Yeah, okay. So, Mr. Party, is it your intention then today to plead guilty to count one, controlled substance, possession of methamphetamine, which carries a maximum penalty of up to 10 years in prison and or a $50,000 fine?
Yes, Your Honor.
All right, are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he has given you?
Yes, Your Honor.
Other than the agreement that there would be no upfront jail, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Mr. Dagger Margosian?
Yes, Your Honor.
And Mr. Party, is that correct?
Yes, Your Honor.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Party?
Yes, I do, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
Yes, Your Honor.
All right, Mr. Party, are you still living in Remus, Michigan?
Yes, I am.
Is your house number 560?
Yep.
All right, we are going to be mailing to you an advice of rights form, and in that envelope will also be a self-addressed stamped envelope for us. There'll probably be 2 copies in there. I need you to sign that advice of rights and put it back in the envelope that's already self-addressed and stamped with my name on it, and mail a copy back to me by putting it in your mailbox or at the post office, okay?
Okay.
All right, so, and do you understand if that plea is accepted, if this plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms on conditions of bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So you're out on bond. So if you commit a new offense or you violate bond conditions, understand I'm not going to be, I'm not going to have to honor the sentencing agreement, and I could give you jail. Do you understand that?
Yes, I do, Your Honor.
Okay. If you are not a U.S. citizen, if you're not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've just given to you?
No, Your Honor.
All right. How do you plead to the charge that on or about August 30 of 2024 in Madison Township in the county of Lenawee that you did commit the offense of controlled substance possession of methamphetamine? Guilty or not guilty?
Guilty.
All right. Mr. Rodriguez, did they bring you the forms yet?
No,
They'll
ma'am.
get them. Don't worry. They'll get them. All right. Has anyone, Mr. Party, made any threats or promises to you to induce you to plead guilty to this charge? I think I already asked you, but I'm asking you again.
No, Your Honor.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, Your Honor.
Mr. Party? I'm sorry, Mr. Dagger Margosian as well?
No, Your Honor, thank you.
Okay. Has your attorney promised you any particular sentence or estimate what your sentence will be other than the no upfront jail?
No, Your Honor.
All right, and it's your own choice to plead guilty?
Yes.
So, Mr. Party, on August 30 of 2024, were you in Madison Township in the county of Lenawee?
Yes.
And did you have in your possession methamphetamine?
Yes.
Did you know it was methamphetamine?
Yes.
Did you have any legal right to possess it?
No.
Are the people satisfied, Mr. Sneed?
Yes, Your Honor. Thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Sneed?
Yes, Your Honor.
Mr. Dagger Margosian?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. Mr. Dagger Margosian, are you available July 18 at 8:30 in the morning? 8:15 in the morning.
Yes, I am. Thank you.
All right. So, Mr. Party, I'm going to set this for sentencing on July 18 at 8:30 or 8:15 in the morning. I'm going to set that via Zoom because there is an agreement to no upfront jail. And I know where Mecosta County is. And so that's a little bit of a drive. I'm going to put you, yeah, but you're still going to have to make one trip here because you're going to have to do your pre-sentence report. And so Mr. Jones yep, where'd Mr. Jones go? So I'm going to put you in a breakout room with Chris Jones from the Michigan Department of Corrections, and he's going to give you some instructions. When you meet with them, be truthful about your background, be truthful with them about the events that occurred, and they will prepare a pre-sentence report. Make sure you reach out to Mr. Dagger Margosian in advance. He's really good about it. And review that before the day of court. You can't appear via Zoom because of the plea agreement. But understand if you violate or you commit any new crimes, I can change that to in person. All right, so we will see you back on that day and your bond's continued. I'm going to open up a breakout room with Mr. Jones from MDOC and I'll give you some instructions, okay?
Yep, thank you.
Thank you. Okay.
All right, let's change things up. Let's go to the great state of Texas, Jefferson County Court at Law number 2. This is Judge Terrence Holmes.
0972. The case is styled the state of Texas versus Sam Lewis. Mr. Lewis, is that your full name?
Yes, sir.
Okay. Mr. Lewis, you're pretty sharp today.
Thank you.
You're welcome. Now, Mr. Lewis, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lewis, you may put your hand down. Mr. Lewis, you're represented in your case by your attorney, Attorney John Macy. Attorney Macy, how are you doing?
I'm fine, Your Honor. Thank you.
And Mr. Macy, do you waive a record in Mr. Lewis's case?
Yes, Your Honor.
Mr. Lewis, I have before me a document that is titled information. This information is on my computer. In this information, it alleges that you, Sam Lewis, on or about March 20th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Lewis, do you understand what you have been charged with?
Yes.
To this charge, Mr. Lewis, how do you plead guilty, not guilty, or no contest? No contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Lewis, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document? On page 2 of this same document, there are a set of initials on a line next to the box that's checked no Hendry, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of the same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? The second statement says that you are waiving your right to an appeal. Waiving something means you're giving it up. You have a right to an appeal, but you're waiving it or you're giving up your right to an appeal. Do you understand that statement? All right. Now, I have another document on paper that is titled Discovery Certification. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? Mr. Lewis, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge? Mr. Lewis, are you a citizen of the United States?
State up, state one.
Any objections?
No objection, Your Honor.
No objection. States exhibit number 1 will be admitted. Mr. Macy, you have advised and counseled Mr. Lewis. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Lewis, your attorney, Mr. Macy, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. Lewis, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 90 days probated over 1 year, $300 fine, 40 hours community service, and court cost.
Mr. Macy, were you opponent?
Yes, Your Honor.
What is the score cost?
What is it? Still can't print them. I have a list on what I need to print down.
Mr. Lewis, the state is offering that you serve 90 days in Jefferson County Jail, but you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 for score costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $167 a month. Are you able to pay the $167 a month?
Yes.
You are. You will also be required to perform 40 hours of community service, and you will be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Lewis, do you understand the state's offer?
Yes.
Do you think that the state's offer is fair and just? And do you accept the state's offer?
Yes.
Mr. Lewis, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Lewis, you stand next to the bailiff, follow her direction. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
You are. And Mr. Macy, is this your only case?
Yes, Your Honor.
You're free to go as well and you have a blessed day.
Thank you, Judge.
Let's head back up to Michigan, where Judge Middleton is about to do a sentencing.
Jesse Joseph O'Shea, file number is 25819 SM. Mr. O'Shea is in custody presently, and he's here this morning. Good morning, sir.
Good morning, sir.
He's here with his lawyer, Rhonda Ives. This was a jury day, and we didn't have a jury trial today, so it's relatively blank. Put this matter in here last week with Ms. Ives, and I've scheduled a few catch-up landlord tenant matters this afternoon. I have jail arraignments this afternoon because the magistrates aren't here, so we'll have some things going on a little later. In the instant case, the defendant is charged with domestic assault, second offense. Let me get into the file. That charge was reduced with a plea to domestic violence first offense. Domestic violence first offense is punishable by up to 93 days in jail and a fine of up to $500. The defendant entered that plea on May 30th. So I didn't exactly set it 10 days out, but the defendant is in custody in the jail. Ms. Ives was scheduled to be here this morning. and he's wanted in a couple of other jurisdictions, and I canceled his bond. To credit the prosecutor's victim advocate staff, they're here, and they did get further contact from the complaining witness, Marissa Smith. And she is not here today, but she provided correspondence in the form of an email, which I'll read into the record. And it appears she's not asking for additional jail time. I want to start this by saying I'm in no way making an excuse for Jesse's actions. The actions that caused that night were not his alone. He should not be the only one to face consequences when I did wrong as well. He was absolutely not just abusing me. He had never put his hands on me before that night. It was mutually combative. We were both being very immature. We did not control our emotions in a healthy way. We together caused things to escalate to what they did, not just him. We were both the aggressors. I know Jesse, the real Jesse, while he's done his fair share of wrong or bad, he truly is not a bad person. He is loving, caring, hardworking, intelligent, and resilient, among so many other things. He is a good person who, like all people, has done some bad things, but that does not make him bad. And that's truly not the person he is anymore. He hasn't been that stupid boy who makes dumb mistakes for a very long time. He has grown, learned, and changed so much over the years. He has put in so much work to better himself in every aspect. Sometimes I don't give him enough credit for that. Everyone is responsible for their own actions, but sometimes you can push so hard, they're able to make you step out of character and do something you wouldn't normally do. And I did that to Jesse that night. I was mad about something small. I blew it out of proportion. I couldn't and wouldn't just let it go. I was saying things that were absolutely not okay, and I just kept going because I wasn't grown enough to control my emotions. So again, while I'm not making excuses for what he did, I'm explaining why he's not the only one to fault and why he doesn't deserve to be sitting in jail for something I took part in as well. I pray that for the little bit of time you have together, you can see him and hear him, the real him. And you know, this is not who he is. He is a good man who is more than deserving of another chance. And I hope you see that too. She doesn't say it didn't happen. She simply offers her perspective on it. The defendant also acknowledged to me that he pulled her hair and put her hands on her, and I felt that was sufficient for the plea. So she's sympathetic toward the defendant, and I'll take that into consideration. And thanks again to the prosecutor's staff for getting that on kind of short turnaround time. Ms. Ives, is there anything else you want to tell me?
Well, Your Honor, I know my client's remorseful. He needs to take care of these other issues. I think he's just sincere that, you know, he wished that, you know, the whole event did not happen, or he wished that he would have handled it differently. I hope that going forward, he recognizes that, you know, his past prior convictions aren't going to help him if he gets in future fights. So he's got to learn to control his emotions and walk away from, you know, battles and not aggravate them further. He's had a lot of time to think about this, and now that he's incarcerated, this is going to give him a chance to get these other matters taken care of, because I think he does have a lot of potential, Your Honor. And I think he knows that now that he's really had to have some reflection on the whole matter. Hopefully the court will give him time served and let him move on. Thank you.
Mr. O'Shea, is there anything else you want to tell me?
I'm truly sorry about it. Obviously, I don't want anything to go back on her, so I would rather just like do whatever I had to do.
Well, I thought you were pretty straight up with me at the time of the plea on the 30th. You acknowledged that you pulled her hair.
Yes, sir.
And put your hands on her, and
Yes, sir.
that's sufficient, whether it was a mutual or not. You're wanted in Crawford County, which is Cadillac, and you're wanted in Van Buren County, which is Paw Paw. And you've been in our jail for 32 days. I'm gonna give you 32 days jail credit, 32 days. This is a second offense, so there's, I don't think, a need to put you on a domestic violence treatment program. She's not seeking that. You're wanted in these other jurisdictions. I don't propose a probation. I'm gonna make the fines as minimal as I can. 0 fine, $125 in state costs or 2 additional days. And I'm gonna waive the attorney fee. I'm gonna indicate may be released to Crawford or Van Buren County. Well, there's a saying that I say a lot. It's also in Latin, but I'll say it in English. The truth is somewhere in the middle. And that may be the circumstance here. You two don't have any children together. There is not a no contact provision. I've simply given you credit for jail time served, let you go to your other 2 jurisdictions. So nothing prohibits you from having contact with her. I think Ms. Ives's admonition was pretty on the mark. Keep doing this, you're gonna have some real problems, but you're good to go as far as this case is concerned. All right, good luck.
Let's head back over to Wisconsin. Judge Mogan, I believe, is also about to do a sentencing.
We will go on the record in the matters 24 CF91, 24 CF109, State of Wisconsin versus Justin Starkey. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Starkey appearing in person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of these cases. Mr. Starkey pled guilty on March 7th, 2025 to 2 counts, 2 felony counts, 1 battery or threat to a law enforcement officer, and 1 count of, I believe it was felony prisoner throwing or expelling bodily substances, an I felony. The court ordered a pre-sentence investigation report. The court has received and reviewed the report. And in my review, even though I don't have as much detailed information as the counsels, the attorneys, I did not find anything that jumped out to me as being a material error or a fact that needs to be corrected. Mr. Schmidt, did you receive a copy of the PSI?
I did.
Any material facts or corrections to state on the record?
Not a correction per se, but he did get revoked in his Polk case and they just haven't done the sentencing yet.
All right. And do you know if that matter is currently scheduled for sentencing?
It was scheduled for sentencing yesterday, but Mr. Starkey didn't have an attorney. I didn't see when they pushed it out to.
All right.
Yeah, I can answer it. Scheduled for the 6th, and I work with the public defender because they'd appointed me, but I hadn't got the appointment, so I'll be representing them in that as well.
Okay, excellent. Thank you. And we are in victims' rights compliance, correct?
Yes.
Ms. Bauer, Victims' Rights Coordinator, are we going to have any victim impact statements today?
Yes, you are.
How many?
1.
Just 1? Mr. Keene, did you receive a copy of that PSI report?
Yes, Your Honor, and I'm not noting any material errors either.
Okay, and did you go over that report with Mr. Starkey?
Yes, Your Honor.
Did you thoroughly go over it with him?
I had a limited time because we had a phone disconnection, but I went over the main points and the recommendations.
All right, and so you went over the bulk of the main information to ensure that he can review if there are any errors?
Yes, Your Honor.
Okay. We will begin with the victim impact statement. The victim may come forward, have a seat at the black bench. Victim may state their name if they wish, or simply the initials. Yes. And if you are going to read something, please make sure that you read it slow, you enunciate your words. The court reporter needs to take everything down accurately, okay?
My name is Jan Lodermeyer.
You can sit if you wish, or you can stand, whatever you prefer.
Last name is Lodermeier. Currently, I'm 911 dispatcher for Burnett County. First of all, I want to thank the court for giving me this opportunity. As a corrections and communications deputy for Burnett County, it was my job to keep inmates safe, secure, and hopefully healthy. When Justin Starkey was unresponsive in his cell the morning of 3/29/2024, sorry.
And that's okay. Take your time. You can take as much time as you need. We have the rest of the morning scheduled for this case. So if you need to stop, you need a break, you can take that time.
My partner and I at the time went into his cell to make sure he was okay, as he was unresponsive. I bent down to touch his shoulder. He didn't really respond. He started to respond. I thought he was going to sit up. He kicked me in my stomach. I went flying back into a cement wall and I fell to the cement floor. The last thing I ever expected from an inmate that was playing, in my mind, possible to attack myself and possibly my partner in the cell. As a result of that action that day, my life has changed drastically. There's things I can no longer do. Correction officer is one of them. As my surgeon is concerned that it could happen again. Maybe yes, maybe no, but after 15 months, the doctors tell me I'm as healed as I'm going to be, which means constant pain, constant numbness, and sometimes tingling down my legs. As for Mr. Starkey, my anger is never going to go away. I am not a vindictive person. But honestly, I hate that man for what he has done to me.
And I'm just going to say, I appreciate your emotion. This is not a time to.
I know. That's all I'm going to say. That's all I'm going to say about that. Okay. I am no longer a corrections communications officer, deputy. I am now a 911 communications deputy. My life now is to help people that appreciate what 911 communications deputies do. And that is to help the community and save the community when we can.
Thank you. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Sure. I'm going to be arguing for what the PSI recommends, which is 2 years initial confinement. Let me just make sure I say it accurate. 2 years initial confinement, 3 years extended supervision on the battery, and 1 year jail consecutive to it on the other count. So effectively, the 1 year jail gets converted into a prison sentence by way of Wisconsin statute. Mr. Starkey has 338 days credit per the jail. This is a 35-year-old man with a traumatic brain injury that was inflicted on him when he was a baby. However, his criminal history only really began within the past 5 years. The implication there is that the criminal behavior cannot be solely attributed to the traumatic brain injury. He has been placed on probation 4 times and been revoked 4 times. He was on probation when some of the conduct at stake in these cases occurred. He is not a suitable candidate for probation. He gets disability, that's been confirmed, and at one point on information belief, I believe he was also getting civil payments from the result of how his traumatic brain injury was inflicted. I do not know if he still gets payments for that today. The core behavior of Mr. Starkey in most of these cases is him assaulting and harassing correctional officers. The assaults and harassment show patterns of deliberation and planning and intention. They were not reactive or in direct response to a frustrating stimulus, such as how people might react if they have a traumatic brain injury and fly off the handle. In 24 CF 91, Justin Starkey was apparently having a seizure when COs went in to address it. You heard an account from the victim in that jail already. As soon as COs were in range, Mr. Starkey shot up and assaulted them, in particular, the full force kick of JL that caused life-altering injuries. This happened March 29th, 2024. The PSI demonstrates a lot of additional information that the PSI writer acquired contacting other jails that Mr. Starkey was in both before this incident and after. And what the PSI writer discovered was that for over a year before this and sometimes afterwards, Mr. Starkey has been in other county jails, and he has been doing the same behaviors. He has been faking seizures and medical issues to trick COs to try and come in and aid him. The jails have reacted in different ways. Eau Claire seemed to have figured out this and just wouldn't go in and expose their COs. They would see the fake seizures, document it, and then document Mr. Starkey's behaviors afterwards, which show he was clearly faking it. Sometimes his reactions have been violent to them not coming in and checking on him, say attacking the door or the cell. His assaultive behavior has also been directed at inmates in those jails. In 24 CF 248, COs came in to talk to Starkey to stop applying cleaning solution to the mirrors in the cells that they use to see in. They first tried to do it in a safe manner through the intercom. He wouldn't listen and kept doing it. The CO went in to talk with him. The CO's posture in the surveillance camera was very neutral. He was not approaching Starkey. He was just casually standing there talking. And then eventually Starkey got mad, assumed a charging posture, and charged at the deputy. It was completely unprovoked. He wasn't even touching Mr. Starkey or approaching Mr. Starkey when he was attacked. 24 CF 109, Mr. Starkey urinated on the wall and floor of his toilet and used a Kool-Aid pack, like the powder solution, to put it on it so it would soak it up to make it clumpable so you could pick it up and it would be throwable, and threw it at a deputy, a correctional officer, I should say. Again, showing deliberation and planning and really an intent to humiliate, I would say. I specifically went through the facts in these jail cases because they show something you don't really see in some of his other cases, this planning deliberative element. Mr. Starkey is intentionally using, not just in these cases, but in the descriptions of these other jails, he's using the empathy of his COs, their desire to help him and to make sure he's not having medical issues to gain access and harm them. He's using positive traits and positive things they're doing against them. It's not just immoral in that sense. It creates a broader public risk to all of the other inmates that COs have to be thinking about and be cautious of other inmates who might be faking just to gain access to harm them. It also shows this more malicious element, because this wasn't a one-off in the JL case of the faking the seizure. We see from the Eau Claire logs, this has been something he's been doing an extremely long period of time. It's a repeated plan that he keeps trying to do and presumably will keep doing in the future. I say that I presume he's going to keep doing it in the future because of how Mr. Starkey talked to the PSI writer about the correctional officer cases versus the case with his mother. The Eau Claire conviction mentioned in there is the one where he assaulted his mother in his home. So that's different than the CO ones. That was a public assault, more akin to the first Burnett County case, the DC in public. And those two cases are more of the getting frustrated and attacking somebody cases. The way he talks about the case with his mother, it's because it's his mother, he says he's sorry. He says something to the PSI writer that when he's asked about whether he feels bad or sorry about what happened, he says just about his mother. He, even at the point when he was talking to the PSI writer, wasn't empathizing with any of these COs, not just the victims in our case, but really the Eau Claire ones, the other county jails where he's done this, the county jail where the CO was coming in with the medical cart, with the medicine that he needed, and he attacked them when they did it. So what am I highlighting? So I've already indicated we have to start first with considering probation. The statute requires that it should be rejected out of hand because of the failures on probation, because two of his recent convictions involved assaults in public in the community, the DC in Burnett, the Eau Claire incident with his mother. The fact he's a danger in the jail to correctional officers itself is also indicative. He can't be treated in the community. That's indicative he needs a higher level of confinement. And that would be the Wisconsin state prison system. They have much better resources. They can have a better documented file and establish easier to use protocols than the county jails he's bouncing to and forth from Polk to Burnett to Eau Claire, and better establish a protocol where Mr. Starkey cannot harm officers, correctional officers. So that brings us to McCleary. Gravity offense, protection of the public, rehabilitative needs of the offender. The gravity of the offense is severe because of the maliciousness of what's happening here, and because of the pattern that can be traced back into 2023 and also forward a bit as well, of really just wanting to attack these jailers. If you look at what is the intent, what is the impetus of why he's doing this, it's not, these are not contacts where the COs are initiating contact with him. He's initiating contact with them by faking medical issues or deliberately doing something he's told not to do. He's seeking provocation. He's seeking physical contact. And as a result, he's harming COs. He's humiliating them. He's caused an injury to one CO that has prevented her from being a CO. That Mr. Starkey has robbed from the county somebody who's extremely talented and experienced in that role forever. We can still keep her in another role, but losing her as a correctional officer is a huge blow to our county. We're constantly trying to recruit new correctional officers because that's a hard position to get people and find people who can do it. And Mr. Starkey exacerbates a real public problem. And that's indicative of a higher gravity offense and also the nature of the injury. We need to be able to protect our correctional officers. And I think that through the gravity of the offense, through McCleary, is the way we address that. Because there are not special rules for the police or for correctional officers where people can swear at them or be mean to them or throw urine at them or assault them, and they can't for the public. The COs and the deputies are also the public because they're also people, and they deserve the same respect. And they deserve the same respect for their personhood and their bodily autonomy as anybody else. Protection of the public is odd here because, like I said, most people don't think of correctional officers or police officers as the public, but they are in the sense of how that term is used. When you have an individual who's incarcerated, the public that we're seeking to protect in this case is the correctional officers. But there is also the broader public who's at danger with Mr. Starkey. One of the read-ins, the case that caused him to come into our jail to begin with, was him being public and threatening a woman who, again, was just trying to help him. We're with the failures on probation, with him assaulting people in public, trying to help them, with him assaulting correctional officers who really just, their main goal is to have a neutral, safe environment for all the inmates and themselves to keep everybody happy. They're not going in there and picking fights. And his disruption of peace, both in the community and the jail, indicates a strong need to protect the public that I think prison is necessary. That brings me to rehabilitative needs of this offender. Mr. Starkey, I think we see a pattern over the past 5 years where he's growing increasingly antisocial and malicious in both his behavior and his thought processes. This can't be traced to his TBI from 1991 because he doesn't have this criminal history going back to 1991. It happened in the past 5 years. They're a result of him and his choices and his behavior. We really see in the PSI, in his statements, a profound lack of empathy for people he doesn't already have a personal stake in. That's why he feels bad about his mother, but nobody else, not the woman helping him at the hotel, none of the correctional officers he's ever assaulted or thrown urine at, of which there's no justifiable reason. They demonstrate an increasingly selfish view that Mr. Starkey has, where if someone makes him angry or he feels he's not being respected, he says to the PSI writer, he's justified in what he does. That's highly concerning because it shows a lack of respect for others, a lack of respect for bodily autonomy, which is really one of the cornerstones of modern society. If his empathy is non-existent to this extent, if he's this selfish in his worldview, if his locus of control is so internalized, what that means is we have to rely on punishment to deter his behavior. There's no other choice because the decision to change isn't going to come organically from Mr. Starkey. He's been continually assaultive for years now in these jails. So it has to come from fear of punishment. It has to come from deterrence. If we don't address punishment through the criminal justice system in that manner, my big concern with the implications of how Mr. Starkey talks about his TBI and his ADHD is he's going to come to the conclusion that so long as he ties things back to that or medical issues and he doesn't get punished, then it's going to reinforce the behavior. If he's able to use those diagnoses as an out to avoid punishment, then he's being told, you can still do that because of your condition. And I take specific umbrage at that in particular, because there's a lot of people out there with TBIs, with ADHD, and other conditions. These don't apply to Starkey in particular, like schizophrenia or bipolar. Conditions that can cause a person to behave erratically or become violent or aggressive. And a lot of these people, most of these people, don't get assaultive. They don't have criminal histories. They aren't attacking people in jails. They're not even in jails because they're still capable of having free will. They can still make the choice to, hey, I want to better myself. I want to get along in society. I want to treat my condition. I want to be responsible. They're not playing up their injuries. They're not playing up their illnesses. They're being responsible members of society. And there's no reason Mr. Starkey can't either. Prior to 5 years ago, that's what he was. I asked the court not to reinforce that behavior. I asked the court to do a prison sentence to deter it. I think based off of the sheer volume of people hurt, the consistent pattern of behavior before and after these assaults, the nature of one of the read-ins being in the community, and the past conviction in Eau Claire not that long ago, also being with his mother in the community, I don't see how it's possible to supervise and treat Mr. Starkey safely in the community. We've seen through the facts of the case themselves, he can't be safely treated or rehabilitated or deterred in the jails. So the next step has to be prison. I'd ask the court to follow the PSI recommendation. Thank you.
Thank you. Mr. Schmidt, before I move on to the defense, one of your focuses was rehabilitation. Punishment was an aspect as well, but rehabilitation, where the court should look at that. And the fact that in this last 5-year history, that your argument stated that Mr. Starkey, excuse me if I'm not saying it as eloquently as you did, but Mr. Starkey was not availing himself to the rehabilitative services. What would you recommend as in at least conditions for rehabilitative needs?
That's the rub of it, because like I said, I don't think the 5-year behavior can be attributed to the traumatic brain injury. There has to be something else going on, which means I think he needs a mental health professional to assess him and work something out and potentially even get some sort of medical paradigm going if a sedative. That's why I think the Wisconsin State Prison System is better, because they have a better medical system.
All right. Mr. Keen.
Well, Your Honor, first, acknowledge Dispatcher Lodemeyer's statement. It's powerful and sad, and no matter what you decide today, unfortunately, we can't go back to that time. Mr. Starkey can't go back to it and undo it. And I'm sure that I presume the deputy dispatcher appreciates the support by many members of the local law enforcement, because in a department the size of Burnett County, that's a fair share of the number of officers who could be on the street. So now moving to a little to the fact of the matter here, but I wanted to acknowledge that first. Not going to deny that it's a serious offense. Dispatcher Lodemeyer has had a change in her career. I read her statement talking about losing her ability to golf. And to say that isn't a severe and a lifetime consequence would be, trying to make a mockery of things today. And I am not going to do that. And I certainly don't agree with the idea that, yes, law enforcement is by nature a dangerous job, because law enforcement officers are called to deal with people when things are at their worst. And in a correctional setting, the correctional deputies are there for people who have either been convicted or being charged with criminal acts in the community that often involve violence and or substance abuse and mental health issues. That said, I would never try and say that's like a mitigating factor because, well, that's part of their job, because, if we believe that, then trying to find anyone to be a correctional officer if they don't feel support is going to be harder than it already is. But the question you have, and the one I thought of, and the one the DA has thought of, is what should happen to Mr. Starkey from here on out. And if you look at his record from 2021, February 2021, so we're looking at a little over a 4-year period. We're looking at a time in Mr. Starkey's life where he's been, kicked out of his home, homeless for part of it, wandering around, in jail most of that time. The last time he was out of jail, I represented him on the probation revocation hearing where he got out. He was put in a hotel for a couple days. And unfortunately for him, trying to get assistance and getting back to housing, because he'd been in custody so long, it was hard to do. And he wasn't able to avail himself of Burnett County's ADRC service because prior to incarceration, his last residence was another county and he'd have to apply there. So I'm not going to argue for straight probation either, because I don't think that the court would treat that seriously. My issue is that, because I've seen this here, with the DA's recommendation and in Sawyer County, one of the issues we have is we have mental health care issues. I'm not talking just about TBI, because the DA's point out that for just TBI, you'd have a longer history or it wouldn't happen at all. But there's certainly some mental health issues that Mr. Starkey's been facing, and something obviously has increased them. But over the past several years, I mean, he had several competency reports because 3 different attorneys, 3 different counties thought something was up. And the competency barrier is fairly low. It's just whether he understands the charges. And then, if you're looking at, mental defect or illness, the standard for that is a fairly tough road to meet. He's in between, I would say. Not in between those, but in between a regular functioning person and someone whose mental illnesses are such that a mental defect defense would be in order. If you look at what's happened over the past 4 years, the vast majority of time he's been in jail. When he's been out, he hasn't really had much for services or time. And, his relationship with his mother was, damaged, obviously, for the Eau Claire case, and she chose not to participate in this hearing. So the state's effort here is to suggest that prison is the place where you can get services. And I think we're sort of doing correction officers, along with Mr. Starkey, a disservice, because we're trying to move along mental health services. You're using prison as a place to provide services that are probably more appropriate in other locations. Because if he didn't have some of these charges, I mean, there'd probably be civil commitments and other items that would also be appropriate. Because there you have, behavioral control issues. And then, although he did not express remorse it appeared to express remorse in the PSI, he has expressed it other times when talking to officers. He's expressed that in court. He's expressed that in other situations. So I don't think characterizing him as a remorseless man is there. But, Mr. Starkey's a man whose mood changes, because it's talking about being cooperative some days, not so cooperative other days. Your impression of him probably depends on whether you see him on a good day or a bad day. So I think when you look at the rehabilitative needs, I don't think that a prison sentence is necessarily going to accomplish that, because Mr. Starkey has been in jail for most of the past 4 years, bouncing back and forth. And then when he's out on the streets, he's, hasn't had a lot of the services. The PSI said that he hadn't had really much for mental health care in the past 4 years. So the question is how to deal with it. And I think one way to deal with it would be to, in 24 CF 109, I would suggest a sentence of time served, which according to the DA was 338 days, be appropriate instead of the 1 year in jail. And that in 24 CF 91, I would suggest a consecutive sentence with probation and a period of confinement as a condition of probation of 60 to 90 days from today for a specific purpose. So probation can identify places for Mr. Starkey to receive, get some evaluations, mental health evaluations, whether he needs a inpatient stay at a mental health facility or some other resource, to allow time for that to happen. And because again, the thing that's startling to me is when I look at it, I mean, other than the harm to Deputy Lodemeyer, which I'm not going to at any point minimize, because that, I mean, that's the worst consequence of the case, because, you know, regardless of what you decide, Mr. Starkey will presumably get out of jail or prison. But unfortunately for Deputy Lodemeyer, that's, you know, lifetime consequences. But in terms of Mr. Starkey, you know, like the last time he got out, he was on a street hotel for a few days. There's times he's bounced out. He has, you know, 2023, you know, he's kicked out of his residence. He's a man who, before he started getting in jail, had been getting services through Inclusa, and he'd had a representative payee and other things. And I think if we pursue prison at this stage, we're just setting him up, okay, go to prison. And then when you come back out, you're the same person. Mr. Starkey's, you know, through the conduct, through the, you know, there were four competency reports sought, and, you know, 3 different attorneys had some of the same questions. Mr. Starkey has talked about someone taking his word fines and a lot of other things that indicate some potential, and someone frauding his name and committing crimes. So there are mental health issues that frankly, I don't believe have been diagnosed, because Mr. Starkey has been in county jails for most of the past 4 years. And I think when you're dealing with rehabilitative needs, the way to get rehabilitative needs for someone with mental health issues is to get them diagnosed, because we don't know what medications may be appropriate, because Mr. Starkey's access to mental health in the past 4 years has been spotty at best and limited to what is offered in county jails. And another thing with the conditional jail is that during that time, the county, if they believe that that if probation is not able to, you know, work on getting Mr. Starkey some inpatient treatment or intensive outpatient, whatever mental health provider recommends, because that's certainly not my role, you know, then that would allow the county to file for a potential civil commitment so that Mr. Starkey could get mental help one way or another. You know, because somebody shows potential danger to the community, versus just going straight to the, well, we're going to use prison to warehouse him for a period of time, and then hope that when he gets out, he's, you know, he's close, you know, he may be close to the same boat. You know, Mr. Starkey does have some tools. He's qualified because he did qualify for SSI. He had a representative payee. He does need some time to get those services set back up, because since he's been in custody for so long, he, you know, you have to start from scratch on applications. And I think the better way to focus on the rehabilitative needs and the protection of the community is to get Mr. Stark focus on a program that gets Mr. Starkey mental health in the shorter order than, you know, go to prison, go to classification, because they recommend 2 years. So, I mean, you're looking at almost half a year before civil services. And we know that the prisons aren't a panacea either, because the prisons talk about shortages in services, staffing for mental health, staffing for their own safety. So in essence, we're you know, the DA's recommendation transfers the burden to the prison system, which, you know, useful for Burnett County, but doesn't really do anything more in terms of rehabilitative needs than the proposal we would suggest is, you know, to recommend that time served in 24 CF 109, which is the 338 days, 24 CF 91, consecutive, you know, 3 years of probation with, I'd say 60 and 90 days of conditional jail, to allow for probation to try and figure out, you know, if there are services they can get them into through Department of Corrections, whether it's a halfway house or some other supervised environment. And if the needs are more severe, then the county could, through Corporation Council, consider a mental health evaluation or hold versus just hoping that we make the problem go away by prison. Now, regarding protection of the community, and I will include the jail staff and I'll include the correctional officers in the Wisconsin State Prison System, focusing on the mental health treatment to deal with whatever Mr. Starkey's issues may be that go beyond TBI would probably do more to protect the community than just, go to prison for a few years and hope that they can provide you resources you haven't been provided in the past 4 years. Because Mr. Starkey is, like I said, he hasn't had them for the past 4 years, a supervised placement with mental health services would probably do more to protect the community than just make him the problem of the Wisconsin State prison system. So with that in mind, like I said, I'm not suggesting a pure probation. Suggest that the 24 CF 109, I think our argument would be treat that as, use that for the time he spent in jail. And then in 24 CF 91, I'd say 60 to 90 days of conditional jail, and that's consecutive. So to the 24 CF 109 with 3 years probation to allow time to coordinate some mental health services and between probation and potentially the county decide if that, how Mr. Starkey can get some of those services that he needs rather than just trying to turn the jail and prison system into the mental health providers. Thank you.
Thank you. Mr. Starkey, I'm now going to go to you and ask if there's anything that you would like to share with the court. And you can fill the court in with anything that you think that was missing with either attorney's arguments or anything that you think was missing from this PSI packet, anything that you think that you may have forgotten or didn't recall to tell that PSI author, or anything with regards to any remorse or any other thing with any of these cases. But you don't have to provide a statement today, but you do have that opportunity. Is there anything that you would like to say? And you can take as much time as you need or would like.
Could I
You can talk
talk
to your
to
attorney
him
too.
first?
Sure.
You sure can.
Yes. So, like, if you're talking about some of your mental health issues you've been having. Is I really not the thing to focus on. I focus on what's going on in your life. It's constant. Decline since one. There are times you remember expressing remorse to jails. Suggest that versus just okay. Okay.
All right, Mr. Starkey.
With the officer that I kicked, I'm very sorry that I did that. I didn't mean to do it. Right after I did that, when I got put in one of those single pods, I actually cried really hard. And I feel really horrible for that. When I cried really hard, I was looking up and I poured my whole bottle of soap all over myself, still with my clothes on. Because I did that to a woman officer. I did not mean to do that, so I'm sorry if she is still here. And with any of my mom's cases, I've already said sorry to her. So that's pretty much it.
All right, thank you, Mr. Starkey. And Mr. Starkey, if I am going over anything when I say anything here in my decision and you don't quite understand it and you need to talk to your attorney, you can just let him know, tap him on the shoulder, and we will stop so that I can make sure that you fully understand everything, okay?
Okay.
Now, we're here today for the sentencing portion of this case. And in preparing for this, you had to speak with a Department of Corrections officer to prepare that report, the PSI report right here. And so you provided a whole lot of information to the author of this report, as well as giving a whole lot of information to your attorney so he can better understand you and the cases and where you were and where you are here today. Now, in sentencing an individual, a person in front of the court has to look at certain factors. I have to look at first the nature and the gravity of the offense. How serious is this case and the other matters related that may have been dismissed and read in, those other cases that you may not have been convicted of any charges, but they are a part of this matter. The court also has to look at the defendant, your character, your past criminal record, and your needs for rehabilitation, if there are any services that could better help you or help you fit into the community and not be a danger or a risk. The court also has to look at needing to protect the public. And here the court looks at protecting the public as a whole, the entire public, and in particular, other groups of the public that may have been impacted by your behavior, by your conduct here. And in this particular case, it would be not only this case, but the other corresponding cases and other cases that you've been convicted of that the court reviews would be those jail-related cases with the correctional officers or other law enforcement officers. The court also has to look at the effect of the victims involved in the cases and hear their statements and how it impacted them. The court also has to look at any what's called undesirable behavior patterns. If there is a pattern which can come out of the cases and out of the facts, and if it's undesirable, if it shows any negative traits or negative characteristics. I also have to look at culpability, meaning your ability or your making these decisions and your guilt, if there was any intent, deliberation, planning, maliciousness, those types of things. I look at your education and your history, which would include that TBI, that traumatic brain injury, and any other mental health conditions that may have already been diagnosed, as well as the other medical conditions such as your ADHD. I have to look at deterrence, and deterrence means to try and stop others from doing something. And that would be the general deterrence, stop other people from committing similar crimes or crimes of this nature, and specific deterrence, meaning to deter you, to try and stop you from committing these types of crimes in the future. And the court also needs to first look at probation. And Mr. Schmidt, the district attorney, went over that in his argument, that I am directed by my higher courts to first look at probation unless confinement is necessary to protect the public from further criminal activity from you, the defendant, unless you need correctional treatment because any types of treatments or other services outside of the correctional institution has not yet been successful or been sought after, or if probation would unduly depreciate the seriousness of the offense, of the crimes here. When I'm looking at this case, I look at the matter of all of the charges in all of these cases together. And you had multiple cases. I believe there were 4 cases that were in front of this court that you were engaging in litigation. All right. And in looking at these cases and in adding the maximum possible penalty, if you were to go to trial on each of those cases, and if you were convicted on each of those charges in those cases, the maximum possible penalty that you would face would be, it would be a total of 20 years and 9 months of initial confinement. That means initially serving within the confines of a prison and or jail cell, and 20 years of what's called extended supervision. That would be similar to what people think of as probation or parole or something like that. In Wisconsin, we call that extended supervision after release from prison. So 20 years and 9 months of initial confinement with 20 years of extended supervision. That's a lot of time. So a total of over 40 years of a prison sentence with some jail mixed in, because there were, I believe, 3 A misdemeanors and 1 B misdemeanor. The rest were felonies. Through negotiation and discussion and plea talks with your attorney in the state, and in reaching this global agreement, that agreement lowered the amount of potential incarceration and extended supervision. And in the case, the maximum possible penalty that you would face with this agreement would be 4.5 years of initial confinement with 5 years of extended supervision. So there was an extended substantial benefit for you in reaching this global plea agreement. And so you did receive a really good deal in reaching this agreement. The primary dispute here today is I need to determine if this is a prison case today, because I have the state arguing for immediate prison, and I have the Department of Corrections making a recommendation for prison. And I believe the state and the Department of Corrections are on the same path, the same avenue with regards to their recommendations, or whether or not this is a case, as your attorney argued, for probation with some conditional jail. And so in looking at those 2 things, because they're so vastly different, the court will need to look at those rehabilitative needs. And quite honestly, the most serious here, this is a serious offense, everybody acknowledges that, but the protection of the public. And what can the court do to try and ensure the protection of the public? I can't guarantee protection of the public, but I can try and ensure to the best of the sentence's ability for public protection. So that is where the court is looking at here. Now, I did review very thoroughly your pre-sentence investigation report. And as argued by the district attorney, your criminal career, your criminal charges and convictions are not very lengthy with regards to your history, just in the past 5 years or so. You are 34 years old, so that would mean they started around when you were 29 years old. And what happened at that time the court is unsure, and I'm not even sure if your attorney is aware, or even if you are aware of what may have happened or why you have may have went down this other path. Because from the time you suffered the TBI, and that is indicated from 1991, when you were approximately 6 months old, you had that head injury. And from the time that you were a baby until the time you were 29, although you were suffering from some disabilities and suffering from some mental incapacities, you were still able to perform and to be conforming to the public and what a law-abiding citizen should be. You were not engaging in any criminal activities. But then approximately 5 years ago is when it started, and it seems to have derailed because we have multiple cases with multiple convictions, with multiple victims. And if you look at the cases, I don't believe you're necessarily selective at your victims. I believe it's victims of opportunity. And it would not matter, because it looks like you have individuals that you know, individuals that you don't know, people that you may be close with, like your mother, or people who may have authority over you or have the ability to enforce authority to you. If you look at the facts of the cases in front of the court today, and if the court does review your criminal history and those convictions, the court feels that the state is making a very strong argument. The facts play out as the state has argued, that in your conduct and your behavior that harms and hurts individuals, it has been deliberate, it has been planned, there is intent to do harm or intent to be in a position where you could cause harm. And it is apparent with some of these victims being individuals who, as the state has said, has shown empathy to you, has tried to ensure that you are not in harm's way, that you are not injured, that you are not at risk. And when they come and assist you, you hurt them. And it's essentially as a lying in wait, as a tiger waiting and watching its prey, and then attacks. And it causes serious injury to individuals. I believe in the Eau Claire case, I think that it was alleged that you had maybe broken your mother's wrist. In this matter, you have kicked the correctional officer so hard with such force that she was thrown across the room and hit the concrete wall and suffered extensive injuries, where she is now in a form of disability herself and cannot return to a job she loved. And now she is in another position she likes and is doing and is helping people, but that is not the career that she had wished to be a part of. And so you're not only taking away people's health and people's physical health, people's mental health, but you're taking away livelihood as well. Their ability to not only provide for themselves financially, but to feel fulfillment in what they may have been doing as a career. And that's where it becomes a little bit more aggravated when you see the gravity of the offenses, the gravity of the actions, the severity of the actions, and the fact that they are so malicious and deliberate and have so much intent. And there is a pattern that this is what you do. Again, a tiger lying in wait for its prey. So there is that undesirable behavior pattern. And it puts the public at a severe risk. And the issue here is not only the public as a whole, the public in general, because lay people, other people who are not connected to this judicial justice world, are at a higher disadvantage than the officers or the correctional officers that you engage with, because they're not aware of how dangerous you could be or the threat of harm that you cause. But when we're looking at having you in a confined setting, and we're looking at the public as the correctional officers or law enforcement officers, they're aware or potentially aware of the fact that you are a danger, you are a risk, but they can't be removed. They're in that position, that's their job. Their job is to ensure that everyone incarcerated is well taken care of and that they are not a danger to the other jail community. Because it seems like in these cases from 5 years ago until present, they continue to escalate. They continue to escalate in harm, in actions, and in damage caused. And with each passing year, with each passing case, without having the punishment to deter, you become more of a ticking time bomb where you're waiting to just go off and explode on a poor individual who may or may not be aware of the risk. And then you cause serious, sometimes irreparable damage. And I've heard your statement, and I hear that you have remorse for the injury of the correctional officer. And I'm glad to hear that today. In reading the PSI report and your statements to the author, those statements from you were more so like you feel you are the victim. You feel you are the one who is being damaged and controlled because you're in custody. You don't believe you're being treated fairly. You don't believe you're being treated the same as other individuals. And I'm going to say, if you're not being treated as the same as other individuals, it's because of your aggressiveness, your violence, your danger, that the officers need to be in a higher alert. They need to protect more. They need to ensure that you have more restrictions and control so you don't explode and cause damage. In cases where a court sentences, I have to look at the least amount of incarceration to accomplish the goals of the sentence and to ensure that there will be compliance. And so I have to look at the minimum amount of jail time or incarceration to protect the public while looking at the gravity of the offense and the rehabilitative needs. The court also, in some cases, looks at punishment, and punishment is a factor. especially when we have this progressive history of increased aggravated actions and conduct towards helpless, sometimes helpless individuals or clueless individuals, and even towards, as I stated, the correctional officers who may be aware of or should be aware of the extent of your violence. The court can't get around the fact that you are an extreme safety risk. And the number one goal here is to protect the public. I need to protect the public, and I need to do so in the minimum amount of time, which would be consistent with those factors and the needs of the defendant. I do recognize and understand that there are rehabilitative needs and that there could be other mental illnesses or disorders, as your attorney is arguing and stating, and the fact that there should be a mental health evaluation because there could be a need or a potential need for medical treatment. So the court addresses the rehabilitative prospects and will do that with the conditions of either probation or extended supervision to ensure that that can be addressed. The court wasn't aware to the full extent, at least until the argument of the state, that it's not just the jail in Burnett County, it was the jail in the other counties where you are housed, that they knew or were aware of the potential violent propensities, that you could be a weapon, a dangerous weapon. And so if the court were to place you on probation and have individuals who are not protected with tasers, that are not protected with weapons, that are not protected with other things, it would unduly depreciate the seriousness of these offenses and the seriousness to watch and to provide you services. It would be sending out a lion in a chicken coop. So based upon the seriousness of the offenses and the fact that they continue to get more aggravated and they continue to cause more and more harm to the victims, incarceration in prison is the only sentence that the court finds to be appropriate. Because again, it would not only unduly depreciate the seriousness of all of the offenses, the court would not be in a position to protect the public if you were not confined. And the fact that correctional institutions can provide you with treatment and or services before you are released. Your attorney made a statement that everybody would be, if you're sent to prison, that everybody would be just hoping the problem would go away. No one's hoping that. No one believes that that is even a possibility. That is not the purpose of prison. The purpose of prison is punishment, and the purpose of prison is to ensure that the public is protected for that ability, or protected for that amount of time to a high ability for the time that the defendant is incarcerated. That's the goal of prison. Rehabilitation is a goal of prison, but it's not hoping the problems go away or hoping that the defendant gets quote unquote fixed or cured. That doesn't happen. A person can change, a person can make changes in their lives, and they can do so while in prison, but that has to be a conscious choice. The person has to be making the steps while in prison to do that, and doing the classes in prison to make sure that that can occur. With each of the charges, the court is only going to assess $250, the DNA surcharge. You have $500 posted, and that will go towards the surcharges. I'm waiving the rest of the court costs and fees. Your ability to pay is very little. You're on SSDI, but you would need to reapply once you are out of custody and out of incarceration. So I'm waiving the rest of the court costs and fees and only doing the mandatory DNA surcharges. With regards to 24 CF91, which is battery or threat to a law enforcement officer, a class H felony, the court believes that that is a very serious offense and it caused serious injury and an impact on the victim. And the court needs to not only deter you specifically from engaging in this type of conduct and behavior while incarcerated at any point in your life, if ever again, and also has to generally deter the public from this behavior, because correctional officers are doing their job. They should not have to worry whether or not they're going to be maimed, whether or not they're going to be disabled, whether or not they're going to break a bone, or whether or not they may not come home at night on their jobs. And people who are incarcerated need to understand that they must follow the rules and they must not engage in this type of conduct or behavior, or there will be punishment. With regards to that count in that case, the court is going to sentence you to 3 years of initial incarceration and 3 years of extended supervision. With regards to 24 CF109, which is throwing or expelling bodily fluid or substances, a class I felony, the court is going to sentence you to 1.5 years of initial confinement and 2 years of extended supervision. They will be consecutive to each other and consecutive to all other cases in all other counties or jurisdictions. The escalation in conduct and behavior, the escalation in the damage and injuries to the victims makes this case extremely serious, not only to you, the defendant in these cases, but to the public as a whole, to ensure that there is at least deterrence factors. Conditions on extended supervision: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, a mental health evaluation, which would include the MMPI-3 test and or any other similar evaluative test as your agent would deem appropriate and to your comprehensive level. The court will order that you have a psychiatric evaluation and exam, and if prescribed medications, you take them as prescribed. You follow all recommendations of both of those evaluations. I said absolute sobriety. No contact with Burnett County Government Center unless it has court-related matters or you have other county business. No contact with the victims or their residences or their employment. Your no contact will be able to be reviewed at any probation review hearing upon request of yourself through your agent. You are a resident of Polk County. You've always been a resident of Polk County, or for the most part, and not a resident of Burnett County. So this should not impede your ability to travel. You were to have no contact with Burnett County except traveling through. If you need to get to other medical appointments, your probation appointments, those types of things, unless there is approval from the court. And again, that can be received through a request and a probation or extended supervision review hearing. You have 338 days of jail credit that the court will provide to you to use towards your sentence. As to your mother, I don't have to provide that no contact. That is something for the Eau Claire matter and her desire to have contact with you. The court is also going to order that you engage in some type of mental health or therapeutic class or course as it relates to self-control and self-regulation. The court believes that this sentence is not only necessary, but it's imperative to assure the public is protected, because you continue to be risky and violent and engage in escalating criminal behavior and contact with victims. And the court is concerned that the next contact you would have could cause more serious damage than disability. It could cause death. The court is ordering your DNA. You must provide that to the jail. You are not eligible for the challenge incarceration program. You are not eligible for the substance abuse program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that covers everything, Mr. Schmidt.
There's one thing we need to cover yet. At the plea hearing, the defendant stipulated to restitution. The restitution was $1,500 to the victim, JL, and what workers' compensation had paid for a certain period of time, which totaled $8,866.91. In between the plea hearing and the sentencing hearing, the workers' comp paid out more money or approved more claims to be paid. So the insurance company updated the restitution claim and submitted that. So the new total is $24,956.09. I would inquire with the defendant if he stipulates that new claim or if there needs to be a restitution hearing for the difference between.
Mr. Keene.
I think a restitution hearing would probably be in order.
Well, I'm going to order, how much was directly owed to victim in this case? 1,500?
1,500 is directly to victim. At the plea hearing, they already stipulated to $8,866.91.
Well, I'm only going to order what's stipulated to the $8,861.91. He has no ability to pay now while he's incarcerated. Plus, when he's released, even if he were to apply for SSDI, he would only receive about $900 a month in what I'm getting from the packet. And it's workers' comp. It's not the direct victim. So the court is going to grant the stipulated amount in $8,866.91.
With that in mind.
Because I believe that would be your argument, inability to pay.
Yeah. Yes, you are.
Anything further?
No.
From you, Mr. Keene?
No, you are.
All right. Then we are adjourned.
Okie dokie. I got to be honest with you. I'm not sure how I feel about that. I need to think it through. I don't know if there was a good answer, though. So I wanted to show you real quick. You know, Ellie worked so hard earlier today keeping the cables warm to keep the stream flowing to you guys today that she finally conked out behind my chair. So there you go. A job well done, Ellie. You worked hard today. So yeah, we definitely went long today, but that's okay. I think it was worth it. Yeah, like I said, I definitely got to think this one through a little bit. I'm not sure how I feel about it, but we will see. Request for all of you. Hi, Ellie. Yeah, I'll pass along your hi, Michael. Request for all of you. The beginning of summer. Oh, here you are, sweetheart. Come here. Come say hi. Meow, wow. Okay. The beginning of summer is very difficult on YouTube. It is difficult for all creators. It doesn't particularly matter what genre you're in. Everybody's outside enjoying as they should, but it makes life a little difficult. So not only for this channel, but for all of your favorite creators and just people you run across and you think, oh, they did a pretty good job. Do simple things for them. Hit that like button. I know that's hokey and everybody asks for it, but you need it. Leave a comment on their videos or on their live streams. That helps. And if you enjoy what they do, subscribe to the channel. If you haven't subscribed to us and we've earned it today, please do subscribe. Creators need that right now. And it's very helpful. So not just me, anybody that you see. And speaking of which, I just dropped into the chat a link for our friend Michael Groff, who is a regular around here. He's a channel member, and he also does his own content. So do me a favor on the way out the door, click that link and go visit him. He does really good work, and you'll see, just watch one of his videos and you'll realize that he's made to do this. So give him some support as well. I got to go do some non-channel related stuff, and then later today we're going to do some upgrades here in the studio. So if I don't post as much today as I normally do, apologies, but we'll get something out at some point, I'm sure. Otherwise, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour earlier for channel members. So there is a link for that, too, in the pinned chat if you'd like to join us for our pre-show. That's for channel members, and we have a lot of fun. We don't necessarily directly talk about court stuff. I think tomorrow, unless something comes up, we'll probably be talking about this case that we just watched and brain injuries, because I have some experience there. So we'll leave it at that. Go enjoy your Wednesday. Again, we'll see you tomorrow. It's been fun. Take care. God bless.